Welcome. We are visiting basic structure values of the Constitution of India. Particularly, we are visiting the judiciary. The concept is of India as a federal union of states. Therefore, the judicial organ as well is of two basic parts: union judiciary and the state judiciary. Each state of Indian Union has its distinct judicial system. Each state has a high court and each state has the subordinate courts. Today, while we are focusing upon the state judiciary, let us have a visit to Article 372 of the Constitution, which provides continuance in force of existing laws and their adaptations. That means the all laws which were existing at the time of the commencement of the Constitution of India, those have been given continuity. So continuous in force of existing laws and their adaptation. So once the word adaptation as well is there, therefore the necessary adaptations because of the organization of territorial organization and other organizations within the Union of India as well have been properly taken care of. Therefore, while we will be appreciating Article 372, we will be appreciating the judgments of the courts, laws and judgments of the courts, as well having given due legal constitutional sanctity. So there is a continuity. Then Article 375 is another article which provides courts, authorities and officers to continue to function subject to the provisions of the Constitution. You see, laws have been given continuity, and then the courts, authorities, officers as well have been given a continuity. Therefore, there is a big value of the Constitution of India that it has maintained continuity with the past. Then Article 376 provides provisions to judges of the high courts. That means the judges of the Lahore High Court, the previous court in the context of the Punjab. So now, today, let us, while visiting these provisions, have in our mind the Punjab state. Within Punjab state as well as there is a reorganization, so we should have a focus upon Haryana state. Haryana state was created in 1966. Prior to that, it was part of the Punjab state. The organization and creation of Haryana in 1966 as according the structural organization for the Punjab High Court as Punjab and Haryana High Court. So Punjab and Haryana are having a common High Court. Then when we will go to the history, we'll see Punjab and Haryana High Court. It comes in the footsteps of, in the respect of Haryana, Punjab High Court. And the Punjab High Court comes in the footsteps of a Lahore High Court. Therefore, while we will be tracing the adaptations of the laws, then we will be having in our mind that there was a Lahore High Court, then we had a Punjab High Court, then we have Punjab and Haryana High Court, while we will be appreciating the interpretations of the laws and the binding authorities in different parts. Now see, these provisions as these are also having, say, section 200 and article 219, this is the oath or affirmation by judges of the high courts, restriction on practice after being a permanent judge, how the judge becomes a permanent judge has a restriction for having a practice in that very court, salaries, etc., transfer of judges, appointment of acting chief justice, appointment of additional and acting judges, then appointment of retired judges and jurisdiction of existing high courts. These all are, in a way, the attendant conditions, circumstances of creation and maintenance of a institutional functioning. Now, in this light, let us see that Chapter 6 is providing subordinate courts, appointment of district judges, validation of appointments of and judgments, etc., delivered by certain district judges, the recruitment of persons other than district judges to be judicial officers, control over subordinate courts, interpretation, applications of the previous chapter to certain class or classes of the magistrates. Now, these provisions, as these are providing us how the institution is foundationally being created to deliver a justice. The justice delivery system appreciation can be had in the light of these constitutional provisions. So this constitutional apparatus is to be visited, and we have to imbibe the values of this set of constitutional apparatus. As it is in the background of this, we will be having proper appreciation of the justice delivery system. Now, this will take us to the state that how in 1947, how in 1947, when the partition was there, Punjab came and became part of the Indian Union. So the Lahore High Court jurisdiction had ceased and the Punjab High Court jurisdiction had come in. So our first Chief Justice of Punjab High Court is Honorable Mr. Justice Ramlal. Therefore, to have the proper appreciation how the continuity values and the values of justice delivery system was put on proper foundations, and for this the role of Honorable Mr. Justice Ramlal is of foundational value. We, the students of law, we the lawyers, and we as scholars and law analysts shall, while visiting the values of justice delivery system in 2020, we shall go to the year 1947 on 15th August 1947, when Honorable Mr. Justice Ramlal had taken an oath, had become the first Chief Justice of Punjab High Court. The seat was at Lahore, at Shimla. Now, in this background, we shall continue our case how the different Chief Justices had in continuity contributed and enriched our justice delivery system. But to have a proper appreciation as to how this judicial sovereignty, as we had seen, Indian sovereignty had a one chunk as fundamental rights of the citizens of India, and the rest of the judicial sovereignty was distributed in judiciary, legislature, and in the executive. As far as the judicial sovereignty domain is concerned, with respect to it, we have to see how the High Court, then the subordinate courts, and ultimately the judicial magistrate and judicial civil judge at the first foundation state. We have to appreciate as to how this constitutional, institutional values index is to reflect in the light of the values index of the persons who will be occupying these chairs. Therefore, we shall have a concrete model before us for appreciation. And it is in this context, as you all know, and all you are well having personal in connections with Justice SD Anand. So I am putting up that let us take the concrete case of Justice SD Anand. Justice SD Anand is retired, and he has retired as a permanent judge of the Punjab and Haryana High Court. He has been elevated from the Haryana state subordinate judicial cadre. Now, Justice Anand has written 3 books, and first book is Barring the Facts Prism is Mine, is his autobiography. The second book is Living in Vestibules, and the third is Existential Dilemma of Justice Delivery System. I know that you have copies of these books with you, and you must have read it as well. But now I impress that revisit these books and have a critical appreciation of the journey of an individual beginning as sub-judge, reaching up till the elevation stage of district and session judge, and then also as district and session judge, as a member of a superior judicial service of state of Haryana. He has also undertaken the responsibilities of district and session judge vigilance, and also as a legal remembrancer of the state of Haryana, a law secretary, and the registrar of Punjab and Haryana High Court. These posts, these responsibilities, and the existential dilemma of justice delivery system expressed by him deserves to be visited by us. Let us have a deep analysis of the existential dilemma faced and expressed by Justice SD Anand. By having an appreciation of these realities through which the individual judicial officer has to be through, and the environment and circumstances in which the individuals have to come up to the expectations of the ideals of the institution, the constitutional expectations from the institutions being manned by the individuals. Now, this reality appreciation will ultimately become our index of experience, and it will also be index of our experience, wisdom, intelligence, and the deep core to which we could dive. So, Justice SD Anand is a second generation judicial officer. His father was also a judicial officer of state of Haryana. His father was member of Superior Judicial Service of state of Haryana. His elder sister as well has been the member of Haryana State Judicial Service, and she was elevated as Judge of Punjab and Haryana High Court. Now, this background which I am impressing is simply to point out as that to have appreciation of the justice delivery system of state of Haryana, we also have to have proper appreciation of the background of the individual judicial officers. The judgments of Justice SD Anand is one class of literature. His three books, which are autobiographical expressions, also gives us much insight into the reality frame in which the individuals function. And then we also have to be face to face with as to how the judiciary, subordinate judiciary, the subordinate judiciary courts, buildings, and all connected aspects have institutional recognition and growth, and still there are many, many limitations when now we are in a transition stage of transformation of the system because of the electronic technological breakthrough. The courtroom, the recording of evidence, searching of law, making submissions, and all these aspects which are part of the trial phases and stages are under transformation. This revolution from the mundane processes, man-made steps processes to electronic gadgets, assistance, permissibility is the phase and stage which also will be appreciated well when we will be through these three books of Justice SD Anand. All this I am impressing simply to make a point as that the justice delivery system is to be appreciated as flowing through the pen of an individual who occupies the institutional seats. We as lawyers, as officers of the court, as well have human factor contribution. And like that, the judicial officer presiding the chair also has human factor contributions. Therefore, the appreciation of justice delivery system should be not only in the light of the academic ideals, but in the light of practical human limitations. Thank you very much.
Thank you.
Thank you, sir.